One person who's been studying this, has been helping the Legal Practice Council actually draw up the codes relating to transformation, is Thabo Masombuka. He joins us now. Thabo, good afternoon. Thanks for coming in this afternoon.
Good afternoon, and thanks.
I suppose when we talk about transformation, we need to start with what are we trying to do before we even begin an assessment. And we're trying to do several things, I think, when it comes to our judiciary. We're trying to change the way it looks. The identity of the people is important. We're also trying to ensure that the judgments that we get through, the way that the whole system works, also is compliant with the Constitution and speaks to transformation within the Constitution. So I suppose the question to start with, it's not a simple question, is what are we trying to do with transformation?
Thanks, Stephen. I think what is important to note is that at least over 27 years since the advent of the constitutional dispensation, it was inevitable that the issue of transformation would come sharply during these interviews, especially of the Chief Justice. It was going to come out because since the Constitution was inaugurated, there has been slow pace of transformation, at least at the level of accelerating what we call historically disadvantaged constituencies into the bench, into the judiciary. And you would have seen the sentiments that came strong when Judge Mandi Samaya was interviewed yesterday, that the very fact that 27 years later after the constitutional dispensation, you still have at least one candidate out of 3 males being a woman for the contestation of the highest office in the land is really, really an indulgence. But when we talk about transformation broadly, we talk about change and progressive movement towards the better and the equity. But in this case, when we talk about transformation in the legal profession, we talk about a number of things that either you tick but ensure that they are implemented substantively. Yes, the appointment of black people in the courts, the various senior, superior courts and the lower courts is one thing, but to ensure that there's quality access allocation of substantive qualitative legal work to black legal practitioners is still a huge challenge. And that's why organizations like the PLA, NADEL, and SAULA, the South African Women in Lawyers Association, have sharply criticized at least the judicial cluster, the justice cluster, for the snail pace of progress in implementing those transformation measures. So I was not surprised that these matters come very sharply during these interviews.
There's several issues here, and it comes down to who gets business, right? And wherever you go in the world, often people will give business to people they know. And in this case, the money, still very much is in sort of white hands. So they're going to give business to people that they know. That's the one thing. But government knows people too, and government's responsible for large amounts of these briefs. And and we've seen it time and time and time again. You'll see a lawyer representing government who's a white male, often on very important cases.
Correct. If you look at the questioning that took place yesterday and during the days on Tuesday during Justice Madlanga's interview, there was this issue of the allocation of work, the briefing patterns. You see, one of the biggest challenges in this legal profession broadly and the judiciary in particular is not just about the appointment of the right color in the right position and the right color and the right gender. It's also about the deliberate allocation and briefing patterns of work and quality legal work. Because you'll get a situation where the Office of the State Attorney, the Solicitor General, which coordinates briefing patterns on behalf of government. But the problem is, and we heard the Speaker of Parliament, Ms. Mapisa Ngagula yesterday said, you still find that these government departments are the ones who insist that we want to use advocates, senior counsel, so and so. Until there's a policy guideline, and that policy guideline can only be prescribed by what we call a legal transformation framework. That is why the LPC, which we helped for the past 2 years develop what is called the Legal Sector Code. Because the Legal Sector Code is going to be the minimum framework that sort of forces the hand of government departments through the Solicitor General's office to allocate work to historically disadvantaged practitioners. We call them practitioners because now there's no difference between your lawyers and advocates. And it's going to make it imperative for them to take into account what we call transformation imperative when they implement briefing patterns.
So we've had affirmative action laws in this country for about 20 years. Now, they're contentious on the one hand because they only say you have to have a plan. And it's only now that we're actually looking at sort of punitive measures to companies that don't implement it. So the question has to then be put in these codes. What happens if the departments, if the people who do the briefing just don't implement it?
So one of the stringent requirements of this legal sector code is not just going to be the Bible. that provides the guidance, and you can choose whether or not to implement it. It's going to be what we call minimum prescriptions. So when it's minimum prescription, it's going to compel accounting officers in those departments to use it. Deviating from it must attract what is called substantive good reasons why you have deviated from that. Now, usually, Stephen, the excuses for deviating is usually scarce resources, technical skills not being there. But now what it says, the usual excuses that say no, because there are no black women attorneys, there are no black law firms that are capable of doing this amount of work. So the legal sector code does not stop there. It says the moment you identify that gap analysis, the moment you identify that breach, where you say there is no skills, there's skills deficit, it places the responsibility upon you as the end user and allocator of these briefs to put into place a plan. And a plan is exactly that. You must implement a plan. It's like a housing plan. You can't have a housing plan that remains that. A housing plan must result into a house that you build. So if you have a transformation plan, and this is going to be a product of this legal sector code, it means you must have a plan that you must implement, and failure to implement that plan must attract what we call consequence management. And the Auditor General's office must come into a place to hold into penalty those departments that are unable or that are reluctant to implement those particular transformation plans.